All right. All right. I think we're gonna, we got quite a few who have shown up. So we'll go ahead and get started. I wanted to say thank you very much for joining us today. My name is Rachel Sterling. I am the COVID-19 Eviction Response Coordinator for Homeline. And so today we are going to have Mike Farah and discussing the updates to the eviction moratorium and the changes that the Minnesota legislature has recently passed that affect the eviction moratorium going forward. We'll also have Andrea Palumbo on. She is a housing attorney here at Homeline, and they will be answering questions. So if you do have questions, we did have quite a few pre-submitted questions that came through, but if you have questions that come up, please put them in the Q&A here in Zoom. So we will go through as many as we can. We do have a hard stop. I know it's supposed to go till 3, but we do have a hard stop at 3:30 if we do need to continue on. So past our scheduled end time. But so again, we will get through as many as possible in this time. We are going to be hosting webinars. We're going to go back to our weekly webinar schedule. Those of you who have been with us since last March when all of this started will know that we had started out with weekly webinars and stopped going weekly, but now are going to go back to weekly webinars as this is a definitely a time of change with lots of things going on, which Mike will get more into in a little bit. So a little bit about us. So Homeline is a statewide nonprofit organization. We help tenants with their legal questions, generally through our hotline. We also offer educational advice and advocacy services. And to date, we've assisted over 265,000 tenants since we were opened in 1992. Mainly, we help tenants through our hotline, either through our actual voicemail hotline or through our email and attorney option that you can get through on our website. And we offer assistance, again, statewide in 4 different languages, Spanish, Somali, and Hmong, as well as English. So as I alluded to earlier, we do have some upcoming webinars. So I will drop a link to register for the upcoming webinar again next week. We will be talking about court updates on the eviction process and any other updates that to the eviction moratorium that are occurring. And again, we'll continue with those updates about the phase outs and of the eviction moratorium, any court updates. Basically, as everything progresses and we get some more either updates or clarity on things, we will be discussing that. So I would highly recommend definitely trying to register for those, and I will drop that information in the chat here. But again, one of the things just want to put out there that especially with the changes that are happening right now with the phase out that's going to be rolled out, it's really important that if you are behind on rent or you have tenants that are behind on rent or folks that you're assisting who are behind on rent, it's really important to go and apply for rental assistance at renthelpmn.org or through 211. As Mike will get more into it, I'm sure, but it's going to be a critical part of that phase out. All right. And then I am going to pass it off to Mike because he's got a lot to cover and I don't want to be chattering away.
Thanks, Rachel. By the way, Eric Hauge, our executive director, not with us today. He is out of town and will be again next week as well. And so Rachel is flying the ship, running the electronics back at the home office. But let's get into this. There's a lot that's happened in the last week, and that's why so many of you are watching today. So to start, the question we've been trying to answer since March of last year, when will Minnesota evictions be filed again? The official governor's moratorium on evictions that was sourced through the peacetime emergency powers that the governor was using during COVID-19, and specifically had 3 different versions that said that evictions couldn't be filed for non-payment of rent, mostly, along with other things, has ended. The last version we had was EO 20 from 2020, 79, the 79th executive order in 2020. And that is now over officially as of yesterday. 2079 is no longer the law or the rule that we're all playing by. It's not really a law, it's an executive order, but it was the decree that we all had to abide by in Minnesota, and that is no longer in force. It was renewed by the governor for 15 months after its initial month, and a legislative agreement was reached. I think it was over the weekend, maybe it was Monday. The official Senate vote, which was the last piece of that puzzle before it went to the governor's desk, and the governor signed it as of yesterday, we've been told. I wasn't in the room, but that's what we've been told when the governor signed it. And so the enactment of the new version of what's been termed an off-ramp, or the eviction phase-out, starts today. So we are in that new era of Minnesota rules. Go on to the next slide, please, Rachel. Okay, so a little bit about that off-ramp, how they got to the decision they reached. The House approved this off-ramp that was a negotiated agreement between leaders from the Senate and the House. And the House vote on this off-ramp wasn't just about the off-ramp. There were other parts of what's called an omnibus bill. But it was largely a party line vote in the House. I can't remember if it was precisely a party line vote, but pretty close to a party line vote. Democrats voting in favor of the bill, and Republicans, almost all of them voting against it. In the Senate, the vote was unanimous for this bill. It was not one person in either party voted against it. It was, I got the impression that there was pressure put on from political leaders of both parties, just say, hey, we got a deal that's done. This is negotiated heavily. And the governor, as mentioned, signed it yesterday, and it takes effect today. All right, let's go on to some of the key parts of this. Go ahead, Rachel, thanks. So what we're gonna talk about are some key phases, because this doesn't all happen at once. The eviction off-ramp phase out. There are several key dates, and we'll talk about the ones that are covered in the law, which I think is referred to officially as a session law. It doesn't show up as a statute because it's a temporary law that's got a built-in sunset effect in it. So that's how I've heard it referred to, as a session law. But here's what we've got. Starting today, again, number one, the executive order is gone. We've heard that the peacetime emergency is being discontinued as of tomorrow as well. The overall peacetime emergency, not just the eviction moratorium. And so we understand that that's going to happen, either that announcement later today or maybe already has. So what can a landlord do right now? As far as, we've got a new rule, or a new set of rules. So what are they allowed to do today that they weren't allowed to do yesterday? Well, let's go over what they can file an eviction for to start. Number one, this is similar to what we saw in EO 2079, seriously endangering others. If the tenant is doing that, the landlord can evict. If the tenant has caused significant property damage, again, we found that in 2079. We also found the violation found in Minnesota statute 504B.171, which is the guns, illegal guns, illegal weapons, illegal weapons, illegal drugs, sorry, prostitution, and possession of stolen property. Those predate the pandemic by almost 30 years, those rules, and they stayed in effect during the pandemic. There was an exception built into the executive order that's now gone, the family member exception. Those of you that have sort of tuned into a lot of these, or maybe just knew about this from your work or from some other reason, knew that there was a built-in family member exception where a landlord was allowed to effectively ask a tenant to go during the pandemic, at least since August of last year on, if they or an immediate family member needed, was the word, to move into the rental unit. That exception no longer exists. It's not in the negotiated off-ramp deal. But something that's new is that the landlord can file an eviction now for non-payment of rent, but there's a caveat here. If and only if the tenant is eligible for assistance, but refuses to apply or work with the landlord to apply for assistance. Rachel's going to, I think she's already posted the language, and she mentioned in the chat box that you need to scroll down. It is line 29 something. It's on the 29th page. It's where you'll see the eviction off ramp start to be covered. And
Mike, the revisers doesn't have line numbers.
oh, it doesn't.
That's why I didn't put it in.
Is there a page number?
No, it's just one big long scroll.
Got it. Got it. Okay. Well, it's
around page 15.
Got it. Okay.
And do a search for Article 5.
Fair enough. There is one portion that's just about the eviction off ramp, basically, and you want to read the whole section throughout. Okay. Anyhow, a landlord is also allowed to non-renew a lease or terminate a lease for a material breach other than non-payment of rent. This is also new. Okay, and this is important. Now, it's critical to understand there's a difference between an eviction and a non-renewal or a lease termination. An eviction is where a landlord has actually filed the court case. Cost the landlord $300 roughly to file the case. There's going to be a court date. There's going to be a case number assigned to it. There's going to be a place where the court is occurring. An eviction, also frequently called in this state unlawful detainer, because that's what they used to be called, is where a court case has been started by the landlord. That's what we mean by an eviction. A non-renewal or a lease termination is typically a piece of paper from the landlord saying, hey, your lease is over. I don't want to do another one with you. I don't want to do another lease with you. Or your month to month, here's your notice that you have to vacate by the end of next month. That kind of thing. That would be a lease termination or a non-renewal. A pretty decent description of the differences between those. And we're going to be talking about those types of differences as we're analyzing the new law, because there's distinctions between those two things. So again, an eviction means court. A non-renewal or a lease termination doesn't necessarily mean court. It might lead to court eventually if the tenant refuses to go, if they get a non-renewal. Let's say that a landlord gave a tenant a non-renewal for the end of August right now. And then on August 31st, the tenant didn't leave. So September 1, they're still there. And the tenant would face an eviction on September 1st for what's called holding over, would be the landlord's option at that point. That would be the only way they could evict at that time. Or they could evict for the material breach if they wanted to do that as well. There's strategic reasons to pick holding over versus a material breach sometimes for a landlord or their attorney. Okay, let's go on to the next slide, please. Okay, so we have another phase that will happen in a couple of weeks. July 14th, here an eviction can be filed for material breach of the lease. So again, note the difference between the eviction and the termination or non-renewal. So on July 14th, 15 days from now, a landlord could file an eviction for material breach. We have heard from landlords, landlord advocates, attorneys that work for landlords, that this is what landlords have been waiting for during the entire pandemic, was the right to evict for material breach. So what's a material breach? Well, there's some case law that tries to define what a material breach is, and it's not all completely consistent. But I'll tell you why landlords have filed material breach evictions in the past and had success. Probably the number one reason that's a material breach that's not non-payment of rent is an unauthorized occupant. All the named adults listed on the lease are living there, and some other adult moves in. Boyfriend, girlfriend, family member, whatever it might be, and they live there. and the landlord files an eviction for an unauthorized occupant living in the rental unit. That is generally a material breach of the lease. Depends somewhat on how the lease is written. There are some nuances to it, but that's a common reason why landlords file for a breach of the leases for an unauthorized occupant. A pet, an unauthorized pet, not talking about some sort of emotional support animal or something like that, but just a regular pet. Somebody wants to get a dog, so they bring a dog in, even though the lease doesn't allow dogs. It explicitly says that dogs aren't allowed. And the lease also has what's called a right of reentry clause built into it, which is a phrase in the clause, a phrase in the lease that says that if the tenant violates a term of the lease, then the landlord is allowed to file an eviction right away. And that's the phrasing for it. It's called a right of reentry clause here in Minnesota. It's a somewhat uncommon rule throughout the United States. And so believe it or not, you'll actually see leases that don't have a right of reentry clause in them here in Minnesota. What's traditionally happened in those cases is the landlord got the lease from somewhere else. Either it's sometimes you'll see giant landlords that own a lot of property that use their lease from other states and think they've modified it adequately here in Minnesota, but they didn't put a right of reentry clause in. Or you get a landlord that just finds a lease on the internet or someplace like that, and they figure it's good enough because it says lease at the top and it looks pretty official. Might even be on legal size paper, so it must be good. But it won't have a right of reentry clause in it, very likely. And so those leases, a material breach might not matter, but a little deeper into that than I should go right now. So again, today a landlord can give a notice. I'm not going to renew your lease, or I'm going to terminate your lease effective, the end of the month or something like that. But on the 14th of July, they'll be able to file the eviction for the material breach. So that's the key difference there. Okay, on to our next slide. Let's move ahead into the future to August. So we go ahead another roughly 30 days, August 13th of this year. So here we have a new lease termination option for a landlord. So this is for a tenant who owes outstanding rent, but is ineligible for assistance through the COVID-19 program. So they've applied, they've been turned down, told they're ineligible. It's probably or else they simply can't apply because they're certain they're not eligible. I'm not sure exactly how that's different from what we have to refusing to apply, but I guess I can see the distinction there. But here, I think the most likely story is it's a tenant that's applied for the emergency rental assistance and they've been denied. So once again, the landlord is allowed to give a lease termination or non-renewal, not file the eviction on August 13th, just give a notice that they're going to terminate the lease or give a notice to vacate at the end of the next rental period or something like that. Seen a couple of questions, by the way, and I'll answer this right up front. We have applied for, or we are applying for CLE credits for today's presentation. For those of you wondering about that, we just are applying today, so we don't have a code approved yet. Once we have that, we will send it out to everybody that attended today. Let's go on to the next speech. I'm sorry, the next slide. And again, we're going into the future another 30 days. We're up to September 12th of this year. Here, it's the same slide that we had before, except now a landlord can evict. Instead of being able to terminate the lease, give a notice to vacate, notice of non-renewal, the landlord can now actually file the eviction, pay the $300, go down to the courthouse and file the eviction. And that is a key date, obviously. And let's go on to our last important date, October 12th, once again, another 30 days into the future. So this is the last of the sort of bullet point phases that we're talking about. There's another one that I'll get to in a second that's kind of an umbrella rule as well. But essentially, on October 13th, a landlord is allowed to file an eviction for any of the reasons they would have filed an eviction for pre-pandemic, give a notice to vacate or a non-renewal for any of the reasons they would have done that before the pandemic, except for one safe harbor provision, which, like I said, I'll get to in a second. But let's talk about notice for a second here. All right. So as I mentioned earlier, landlord advocates and landlord groups have been clamoring for the right to evict for a material breach for months. bordering on a year, frankly. And one of the things that tenant advocates were asking for as part of this off-ramp provision was that there would be a requirement that notice needed to be given to a tenant if a landlord wanted to file an eviction for non-payment of rent. The rationale for that is a couple things. Number one, tenants are just as confused about what the rules are right now as landlords are and attorneys. And I don't know if we have any judges or referees watching, but these are confusing rules. They've changed a lot over the last 16 months. And the reason why our hotline, our tenant hotline, where we get roughly 15,000 calls a year, but the reason why our tenant hotline is ringing off the hook today is because everybody's trying to understand what the rules are. That's why we have so many people watching us today as well. Everybody wants to try to figure out, what do these rules really mean? There's a lot written there. And so how do we get through it? So this notice requirement in the law says that a landlord has to give a 15-day notice to be able to file an eviction for non-payment of rent through October 12th. And the notice has to say that the moratorium has ended and that the tenant can be evicted. Also, the total amount of rent due. Now, I've heard from landlords that, of course, tenants know how much they owe. Maybe they know how much they owe, but maybe they paid portions of rent for several months. Maybe they're not sure how much the late fees are at this point, or any other types of utilities, other typical bills that they might have as part of their tenancy. And so knowing the total amount due is critical. Now, the law only requires that the landlord say the total amount of rent due, something that we argued should say the total that's due, but it doesn't say that. It says what it says, total amount of rent due. However, if I'm a landlord and I want to get paid, if that's the goal for a landlord, wanting to get paid, I would list the whole number that's due. This isn't the limit of what you can list in the notice. It's just the required basics, the total amount of rent due. You could also say, plus you owe this for late fees and other amounts as well. And it also has to include information where to get rental assistance, 211 or Rent Help MN to be specific. The notice portion of this session law is confusing in what is required of the landlord and what the penalty is if they don't completely comply with it. So to start, the law says that the notice must be given, right? And then it goes on to say that if the landlord didn't quite do it right, that the judge has the discretion to stay the eviction. Could the judge dismiss the eviction if there was no notice given at all? I think we'd make an argument that that would be the case. Obviously, there's no precedence on this because the law is brand new today. And so it's hard to know exactly what a judge would do with that sort of thing, but it's really straightforward what a landlord is supposed to do as far as a notice is required with a non-payment case. And it's just in non-payment cases that this requirement exists. And so simply complying with it makes the most sense for a landlord. Again, if a landlord wants to get paid, one of the thoughts behind this notice requirement is this would motivate a tenant that got behind and just kind of, this is a little bit of human nature, but they sort of bury their head in the sand. They hope this all sort of goes away, and they've been there for a long time, perhaps without paying any rent. And then they'll hear that the eviction moratoriums are ending. Should they run out the door? Is that what they're supposed to do? And we will and do get questions from tenants asking that exact question right now. That's not necessarily a great move for a tenant, nor for a landlord, if the landlord wants to get paid, because once the tenant leaves, the money that's available through the federal government routed through the state, it's not going to be coming to the landlord. At least that's how it's designed right now. So the notice serves a lot of different purposes. Remind the tenant that, hey, you know what, this is a business relationship. You owe a bunch of money you haven't paid, but here's a place that you should try to qualify and see if you can get the money so you can get me paid, me the landlord, and you can keep the place. And that's the whole goal of this money, is to stabilize precarious housing for people, so that hopefully going forward, they can get caught up and stay caught up. All right, on to our safe harbor page. So this is the last deadline that we have in this law, June 1st, 2022. What's that, or 2022? What is that about? Well, the landlord can't file an eviction for non-payment of rent during that time if the tenant has applied and they have a pending application for the rental assistance. So it just essentially stops the eviction. So a landlord shouldn't be able to file one. And if the tenant has applied, I think even mid-case, the landlord has already filed the eviction, it probably has to halt the eviction, as the language of the law says that it can't either be filed or proceed at that point. So there's a difference between file or proceed. So yeah, through June 1st of 2022, once again, the theory behind this is there's a giant cargo ship of money that the state has, and it's not just theoretical money, it's in their bank account as near as we understand how the money works. And so it's going to be dispersed eventually, hopefully, if people simply apply properly. And if we want to get landlords made whole, which ultimately is the real result of this, landlords are made whole, tenants effectively get their balance sheet cleared so they get current on rent, that will hopefully restore people to sort of a pre-pandemic spot is I think the goal behind these rules. Now, again, this law was not something that everybody agreed on. I don't think there's any party that got everything they wanted. I believe there was a letter from a landlord group saying that they didn't want this at all when it was introduced in the House, that they just thought it should end the whole eviction moratorium, that there should be a cliff instead of an off-ramp. And so landlords are not jumping up and down excited about this off-ramp. Tenant advocates are concerned about several things. There are other things that we wanted as well. But this was a negotiated deal. There's no question about it. And it's the deal that we have going forward. Most important, this is the law that we're all going to be abiding by moving on. Now, we have to talk about a couple other things. The federal rules. But before we do that, let's look at this sort of timed guide to these the things that I talked about already. So go ahead and illuminate that first one. So this is today that we're talking about here. That was right, Rachel, thanks. This is today. The stuff that we talked about that all happens officially right now. I should mention one other thing about today, which is, as we understand it, the Attorney General's role in this process is now substantially minimized, if not, I'm not sure. They still have a consumer protection division, and so they've dealt with landlord-tenant questions forever, but they don't have the outsized role that they had under the executive order, where the Attorney General's office was the exclusive enforcement mechanism for the governor's order. So the Attorney General's involvement in this issue is, again, substantially eliminated at this point, or at least whittled down a lot. Tenants can still call the Attorney General's office and ask for information, but the AG's explicit role from the executive order is no longer there. All right, and then we go on to the next one. Again, a couple weeks from now, the landlord can suddenly evict for the material lease violations, but not for non-payment of rent. Go ahead into August. Again, the landlords can terminate leases. Again, not evict, but terminate leases if a tenant's behind and ineligible, ruled ineligible for rent help. We go on to September 12th. Once again, the landlords can evict tenants. The difference between eviction and terminate the leases is substantial there. And then last, we have the October 13th sort of end of most of the protections. The only one left is that safe harbor overall protection that goes through June 1st of 2022, if they've applied and their application is pending. Okay, that is the state update, but that's not all we have to talk about. We still have a couple things at the federal level. So first, the CDC, the federal moratorium through the federal government was routed, if you remember correctly, from last September through the Center for Disease Control. President Trump asked the CDC to figure out a way to prevent evictions, and they passed they decreed a moratorium on evictions throughout the country for non-payment of rent. We are now in our 5th time period, or we will be tomorrow. Went from September through the end of December, and then there was one from December through the end of January, then the end of March, then the end of June. And now there's been another one announced for the end of July. So they're extending the CDC federal moratorium on non-payment of rent evictions through the end of July. But we've been told that this is going to be the final renewal. This has been widely publicized that there's not going to be any more renewals after that. The CDC says this is the final one. Now, is there a possibility that, the Delta variant that we've all been hearing about in the media, takes over the country and suddenly the numbers surge up to what they were at the high points in the pandemic? Would they backtrack on that? I suppose that's possible. But right now, it is through July 31. Interestingly, there was a Supreme Court, the US Supreme Court, brief decision on this issue yesterday issued. And it's a little bit shocking here because there's actually a US Supreme Court decision on eviction bans. And in our state, at least, it's not front page news on the landlord-tenant front because we still have our statewide moratorium. The local protections, whether it's a state protection or a county or a city protection, if it's stronger, it's more protective of renters, then the CDC moratorium specifically defers to that. And so there's not much that the CDC moratorium really does for a non-paying tenant, because I guess there's an argument that a tenant could try to use the CDC clause to argue that they shouldn't be evicted under the current rules, where the landlord is allowed to file an eviction today, right now, for a tenant who refuses to apply for the money. But the CDC requires a tenant to state a declaration. It's not notarized, but it's still under penalty of perjury that they have made all efforts to obtain financial assistance from every place that they could. So I don't really think that it does the tenant much good to make the CDC argument in Minnesota still. I think as things are laid out today, it looks as though the CDC moratorium will never have really had a meaningful impact in Minnesota by the time we're done with this entire eviction moratorium era, because there have been stronger protections in place in Minnesota throughout. The CDC moratorium has merely served as a sort of a catch-all backstop at this point. And that might be the only role it ever plays in the eviction pandemic time. The Supreme Court decision was not unanimous. It was 5-4. Justice Kavanaugh was quoted as saying, I don't have it in front of me, but more or less that, yeah, I don't think this moratorium was legal, but it's only going to be another month. So I think we'll let it go. That seemed to be the gist of what he had to say. And he was one of the voters that said, yeah, go ahead and keep this eviction moratorium in place for another month, intimating that if the CDC changes their mind on July 31, extends it for another 6 months, that the Supreme Court would likely not allow it. I think the court's indication was that Congress would have to pass this, that it couldn't simply be a declaration from the CDC at this point. Which leads us to our final hurdle when it comes to, go ahead and go to the next slide, Rachel. When it comes to can a landlord file an eviction? The CARES Act. The CARES Act. Why are we talking about the CARES Act? Well, the CARES Act, enacted back in March of 2020, had an eviction moratorium built into it. That eviction moratorium was only for CARES Act covered buildings, which is defined a little bit on the slide here. It's actually a pretty complicated definition, but this is a pretty decent overview of it. But anyhow, that eviction ban ended last July. Okay. However, there's a 30-day notice requirement in the CARES Act. So what it said was, look, a landlord can't file an eviction in a CARES Act covered building. Our best guess is somewhere between 20 and maybe 40% of Minnesota landlords are under the CARES Act. We don't know for sure because it's difficult to know how mortgages are set up for a lot of landlords without actually subpoenaing the landlord's records. So anyhow, the CARES Act, we saw it played out in several states where there was no state eviction moratorium for some set amount of time. There was no federal one, there was no state one. The CARES Act, the July 25th deadline had passed. But then the landlord was supposed to give a 30-day notice for a non-payment of rent case, telling the tenant, hey, I can file an eviction against you. But that never ended. The July 25th deadline is clear and it's a bright line and it clearly ended, but the 30-day notice requirement didn't end. And so does the landlord have to give a 30-day notice? I think there's a decent argument for that if it's a CARES Act covered building. And so that would be a potential defense for a tenant. It's the kind of thing that I'm going to want to have the answer to if I'm a landlord or a landlord attorney before I file a case. And in some states, there have been requirements that there are, a landlord has to swear that they've complied with the CARES Act requirement for notification. And we'll see how that plays out in Minnesota. Like I said, we haven't really had an active eviction, non-payment of rent, able or allowable setting for 16 months. So we'll see exactly how the courts rule on that once non-payment cases become eligible, whether they say, yeah, the CARES Act does still play a role here, which on paper, it looks like it should. Okay, so that was almost 40 minutes of me filling you in, hopefully, on the basics of where we are today. I know we have a list of questions, but I'm gonna take a break and get a drink and let Rachel talk, and we'll go from there.
All right, thanks, Mike, and thanks for all that information. I'm going to scroll back up to the timeline slide, just because that's probably a little bit helpful for everyone to kind of reference, since we are going to be kind of covering a lot of the if this, then this, and the dates are very important. So I'm just going to have this up here as reference. And like I said earlier, we did get a lot of questions that were pre-submitted. And so we will go through those first. And then we will go through the questions that were submitted in the Q&A. And I tried to note the questions that were left in the chat, but again, the Q&A ones are easier to track. Again, we also will be having a hard stop at 3:30. If we're done magically at 3, that would be great, because that was our scheduled stop time. And this is being recorded now, and it will be available on our Homeline website after this. So you'll be able to, if you have to leave at the scheduled time, you'll be able to view the recording later on for any additional information. So let's go ahead. I'm going to start asking questions, and then Andrew and Mike are going to go back and forth with the answers so that they, and I may chime in at some point. A lot of this is very new to all of us. So you may see a little bit of a brain trust going on between the folks here.
Brainstorm,
brain trust.
Okay. All right.
No, we're a brain trust.
Okay. All right.
All right. So let's start first with, so Greg, who is a landlord, asks, the tenant was served a notice to quit and vacate by midnight, March 31st, 2020. So back last year, but they never left. So they've been current with rent until May of this year, when the rent help MN was started. They applied for that program and now will be current with rent through August of 2021. So also getting forward rent. But there hasn't been a lease for the last 18 months. What point is this process? Can this landlord serve another notice to quit and vacate? So they would like to remodel and sell the house.
Okay,
let's start with Andrea.
Yeah, for starters, if a lease ends and there's not a lease signed after that, then the tenant goes to a month-to-month lease, basically. Just want to mention that. When it comes to notices to vacate, you'll notice with a lot of what we were talking about during the presentation, there are protections for tenants who have applied for rental assistance and they have applications pending. So that's the major protection for tenants that's in place. And ordinarily, a landlord does not have to give a reason for a notice to vacate, but that has really changed with this off-ramp. Right now, a landlord can give a general notice to vacate for any reason way down the line in October. That's when the protections for tenants with pending applications, tenants that a landlord, what am I trying to say? A landlord can go back to giving a notice to vacate for pretty much any reason, except if a tenant has a pending application. So, and to really kind of answer this question, really, notice to vacate could be given after October 12th. Most of the protections that are in place for tenants are going to be off the table at this point. Possibly after August 13th, if there's additional assistance available through Rent Help Minnesota. There's a lot we don't know about the process for getting assistance from Rent Help Minnesota, and it seems that it's intended to be a one-shot deal right now. That may change. So provided that they've gotten all the assistance they're going to get, it really looks like the landlord could give a notice to vacate as of October 13th.
Thank you. All right, Mike, you're up. Unless you have anything to add.
A lot. I want to kind of echo what Mike was saying earlier. This is new. The law has just gone into effect today, and there's a lot of moving parts and a lot of players involved. So we can speak to what the text of the law says, but a lot of this is going to be open to future court interpretation and open to what happens with Rent Help Minnesota and the assistance on that end.
Okay, next question. This is from Beth. She's a service provider. What advice can be given to tenants whose landlords are not renewing their lease or are selling the building?
Yeah. First, they still owe rent during the time that they're there. If they're current, continue to pay rent. If they're not, they should still apply for the assistance from Rent Help. And as looking at the page, and just what Andrea's last answer was, it's not necessarily true that the landlord can make them leave right away, depending on their situation. Might be still some more months before the landlord can actually do this. And this happens. Look, landlords want to sell. Just they decide they don't want to own the property anymore, and so it's not necessarily anybody doing anything wrong. But yeah, to continue to pay and be aware of what we have on our screen right now, that there are times when the landlord will be allowed to do that. Certainly on October 13th, it's a possibility, but between now and then, it's going to be substantially limited.
Right. Thank you. I'm going to keep chugging along because, like I said, we've got quite a few to get through. So this one's from Mark, who's a landlord. I think this is referring to the CDC moratorium. But the question is, can we evict if tenants did not fill out the COVID affidavit? Also, are we still able to enter properties for inspections or maintenance?
Well, to jump to the second part of the question, yes, a landlord is able to enter a unit for inspections or maintenance so long as they give the tenant reasonable notice ahead of time. And the statute 504B does not specify what exactly reasonable notice is, but that really has to be negotiated between the landlord and the tenant. But a landlord can enter the unit for a reasonable business purpose. Minnesota has lifted its mask mandate for most situations. So previously it was mandated that masks be worn in common areas and buildings, but not necessarily in individual units. A tenant can request that a landlord wear a mask when they come into their unit if they prefer to have that happen. And a landlord can ask that the tenant wear a mask while they're doing maintenance.
And if the peacetime emergency ends tomorrow, the mask, whatever mask mandates remain, would be gone as well.
Yep. It'd be basically a non-issue, but it's something that a tenant and a landlord can absolutely negotiate. Now, in terms of the COVID affidavit, I agree with Rachel. That does refer to the CDC eviction order, and for a tenant to get protection under that, they had to submit an affidavit. And that's not the case with the Minnesota off-ramp or any of the protections, that a tenant does not need to affirmatively sign an affidavit. And so right now, a landlord cannot evict, I should say, if they haven't signed the affidavit. A landlord can evict and terminate a lease for the reasons we've gone over and that are on the timeline in front of you. It's not going to hurt for a tenant to sign the affidavit because it does state their situation, but it's really more important if a tenant needs rental assistance that they apply with Rent Help MN.
And there are, once you apply, you should be able to either get some sort of paperwork that shows that you are applied and you're in a pending status that you can use to show, or if you call 211, if you don't have internet access, they should be able to get you those documents. I don't know if that's a timely thing or not, but it is, though that documentation is available to the best of my understanding. Okay, let's see, let's do Sandra, who not certain, I think she might be a landlord, but the question is, what is the procedure to evict someone who has not paid nor applied for assistance?
So if the tenant is refusing to apply for assistance, then a landlord is eligible to file the eviction today. That's one of the new things that they're allowed to do. That's a tenant that just says, you know what, I know I owe a lot of money, but I'm not going to pay. So that is a change from, yeah.
I was gonna say, wouldn't the 15-day notice requirement,
Right.
if it's for non-payment, still apply?
True, they have to give the 15-day notice, but they're able to give that now and have it be meaningful. And so it's a good point. Appreciate that. But yeah, they can file it, you know, once those 15 days are up, the 15-day notice is given. And as far as the process or the procedure, once the notice is given, then it's just filing the eviction like always. I don't think there's some new form that landlords are going to be expected to fill out. I don't know if the court forms are going to say something about the notice requirement, how the landlord has satisfied it. I guess if I were a landlord, I would be writing something about notice, the 15-day notice as per the session law was given on this date. That notice, by the way, there's no requirement as to how exactly it has to be given. It's not strict personal service rules or certified mail. It just says, I believe it says in writing is as far as it goes.
Yep.
Notice. So yeah, on the 14th, they could file the eviction after giving the notice. Thanks for pointing that out.
Absolutely. All right, Andrea, Jeanette is a tenant. And they're asking, well, all right, I'm not 100% certain what they're asking. It just says, evicted, writ served, never received a list of items. I was forced to leave. Can I sue?
This is, Jeanette, I recommend if you are on the webinar that you give our hotline a call. It's 612-728-5767. I'm not sure precisely what you're asking. In terms of if you are asking about personal property that you were never able to retrieve and it was discarded, there are timelines for when for how long a landlord has to retain that, and it's 28 days before it can be disposed of, and you have to get notice that the landlord is going to dispose of it, and if those timelines weren't complied with or the requirements weren't complied with, possibly you may be able to file a suit for the value of the property or the belongings. But I'd recommend that you give our hotline a call so we can get more information and make sure we're giving you the answer that you're looking for.
All right, thank you. Mike, Beth is a service provider and they want to know, how will a landlord prove a tenant is ineligible for rental assistance? Alternatively, how can a tenant prove eligibility?
Yeah, I suppose if a landlord gets some sort of notification from Rent Help that, your tenant that you applied with has been denied, if that's how it works, or if that's how it will work, that would be a sign that the tenant is ineligible. As far as proving eligibility, I mean, the tenant would take, I would recommend something as basic as taking screenshots, even if it's with your phone, of the screen showing the phases of the process that you might be in, if it's hard to get that information from Rent Help directly, to prove whatever you can prove as the tenant. I've applied, they haven't ruled me out yet, my application's still pending. However, that kind of evidence can be either obtained or maintained. We're going to see as the electronics sort of proceed, and hopefully Rent Help will make this easier for people instead of harder.
All right, thank you. All right. Chris is a landlord, and they're asking, my renter is using the moratorium to evade paying rent, even though they are currently working. When can I evict?
Well, right now, if you have a situation where they owe rent and they are refusing to apply for the COVID rental assistance that's available, it is possible to give the 15-day notice and file an eviction at this point. There are limitations on other types of evictions, but if you do have a situation where they are refusing to apply, it is possible to more or less evict immediately, or if they owe rent and they refuse to cooperate, if the landlord is applying for a program like Project Zero Balance, that's something that is landlord initiated and the landlord applies, but the tenant has to cooperate. Or if the tenant refuses to provide proof that they've applied for rental assistance and they owe rent.
And I'm not sure that Zero Balance is taking applications now.
They aren't right now. They closed so that they could process the applications that they have, and it's expected that they're going to reopen, but we don't have a date for that. But you're right, they are closed right now.
Okay, let's see. Michael asks, the lease ends on 10/31/21. Landlord gives notice on 10/13 of termination as of 11/30. So after the 105 days, can I be evicted on 12/1 for non-payment? I think there's a lot of layers in that.
There are some layers in that. Yeah. So if the tenant has applied for the rent help assistance, there couldn't be an eviction for non-payment filed on December 1. However, the landlord might try to file an eviction for holding over if they gave adequate notice under the lease, if the tenant refused to leave on 11/30. So if the lease only requires a 30-day or 1-month notice and the landlord gives notice on 10/13 for 11/30, 12/1, if I'm the landlord, I'm going to file for holding over, not for non-payment, if my goal is to get the tenant out.
All right, perfect. Thank you. David is a landlord and is asking, where do the COVID-19 Emergency Rental Assistance Program and eviction allowances collide? Not 100% certain what David's asking.
Not sure. The COVID-19 Emergency Rental Assistance Program is basically Rent Help Minnesota and Project Zero Balance. They are the approved rental assistance programs that are mentioned in the off-ramp. I'm not exactly sure what the eviction allowances is referring to. Possibly if it does refer to anything in prior executive orders, such as in 2079 that laid out the permitted grounds for eviction. Basically that executive order is no longer in effect. That is gone, and the off-ramp legislation is replacing that. So David, I'm not sure if that's what you were asking, but that's what we can tell you right now.
Fair enough. All right, then Julia, a service provider, is asking, is the 15-day pre-eviction notice just for non-payment of rent, or does it include other eviction causes? And what if someone has both?
So yeah, the
Assume
15,
both, like more than one cause for
sure.
eviction.
The 15-day notice that has been mentioned several times already is just for non-payment of rent. That's the only issue that it applies to. If a landlord has more than one reason to file an eviction against a tenant and they aren't allowed to file for an eviction for non-payment of rent, I would not recommend listing it as a reason if it's not one of the allowable reasons during that time. The main reason why I wouldn't include it is because a judge / referee might look at this and say, it really looks like you're just trying to evict them for non-payment of rent, not because they have a dog. We don't think you really care about the dog. We think you're evicting them for non-payment of rent. So lawyers love to do what we call alternative pleading. If I don't win for this reason, I win for this reason. So I'm going to plead both approaches, whichever one you like, judge, just as long as I win. But listing non-payment of rent, I wouldn't recommend for a landlord if they have a valid reason for material breach.
Awesome. Okay, I'm going to take this next one because Lawrence is just asking if we applied for CLE, and I want to reiterate for those who may not have heard before, we are applying for CLE credit, and you will get an email with that number once it's approved.
Well, I don't fault Lawrence for asking. Today is June 30th. This is deadline day
It's true.
for CLEs.
Exactly.
Those of you that aren't lawyers, every June 30th is the deadline for about 1/3 of the lawyers in the state each year to get their CLE requirements. So somebody that needs 1.5 credits today, they're going to be getting them through this. So there you go.
And all of our other webinars have been approved. So
Well, we haven't
not
gotten
all.
CLE credits for all of our webinars.
not all of them.
No,
Okay.
but when we announce it, yes, they've
Yeah.
always been approved. Yes.
Yeah.
And again, those recordings are on our website. I will post a link in the chat. But in the meantime, while I do that, let's see, I think we're on Andrea, or no, we're on, back to Andrea.
Yep. it's me.
Chris, who is a landlord, wants to know, when can I legally give notice to vacate? Tenant is fully paid on rent. They just want to do something different with the property.
Okay. Yeah. We've gotten a few questions about this. Kind of dovetailing with what we were talking, what I mentioned earlier. Ordinarily, in non-pandemic, non-COVID times, a landlord is able to give a notice to vacate more or less any time, so long as they give it with the legally required notice that's within the lease, or at least a rental period's notice if it's a month-to-month lease. That is most likely not the fact until after October 12th of this year, provided that the non-payment of rent is not an issue. If the tenant is no longer current with rent at any point, they are able to make an application with Rent Help Minnesota, and then that will kick the protections in that are present in the off-ramp legislation against eviction for non-payment of rent. So for something like that, where you just want to give a notice to vacate, you want to do something different with the property, and the tenant is current on rent, unless there's a material violation of the lease, you're really looking at giving a notice to vacate in October 13th.
Thank you.
And like I said, a lot of this we're still working out. This is new stuff.
Mm-hmm. Yeah. So Clara is a service provider and asks, will tenants be evicted for not paying rent? What are their options before court proceeding? Mike, you're on
If
that
the tenant
one.
is behind in rent, the tenant should apply for rent help assistance. I think even through the eviction case, right? I would apply the day before the court hearing, and still make the argument that, hey, I applied, so this is a pending application. So if a tenant is being evicted for not paying rent, they should apply for rent help, would be the #1 piece of advice. And through June 1st of next year, that's a defense to the case, and What exactly will happen to the case, whether it'll be stayed or paused or what phrase they'll use for it, we're not sure yet, or if it'll be dismissed. But it's supposed to not proceed once the rent help application is in. But the tenant should apply, because again, right now, the landlord, if they give the 15-day notice, then they can file the eviction for the tenant refusing to apply for the rent help.
Mhm.
All right, so kind of in line with that as well. We're talking about the 15-day notice. Minneapolis just passed their new ordinance that requires a 14-day notice, just from here on out, since I think the end of May, for non-payment of rent evictions. How does that play in with the off-ramps 15-day notice? Andrea.
That is a really good question. Rachel and I were discussing that before the webinar. I am not positive when the Minneapolis ordinance takes effect, if it hasn't already.
It has.
Okay, it has.
And the reason why we don't know this as eviction and housing attorneys in Minnesota is because it hasn't mattered, right? I mean, nobody could file a non-payment of rent eviction, and they still, in most cases, can't. So the Minneapolis ordinance was passed largely in anticipation of the end of the moratoriums, saying, hey, you know what, if the state can't figure out how to require a notice, at least in Minneapolis, we're going to have this rule. Although I don't think it's limited to the pandemic era. I don't think it's got a time limit on it, the Minneapolis ordinance. I think it goes forever until they change the rule.
Right. Right. So I can't say for sure. If I was the tenant, I would argue that I'm entitled to the 15-day notice, because that's what's in the off-ramp. The court may look to somehow make sure that both the city ordinance and the state law are both complied with.
The city ordinance does, there is one key difference in the notice requirement, which is it requires the landlord to offer some more information about how much is due. It's not just rent, it actually refers to late fees as well. And it asks for a specific accounting of what the tenant owes. So again, not hard for most landlords to do, to just, here's your ledger, right? Here's what you owe, this is the total due. But the Minneapolis ordinance does have a stricter notice requirement on what the landlord has to give.
Right.
And again, the 15-day notice is only applying, in the off-ramp legislation, actually is only applying to evictions for non-payment of rent. And in the Minneapolis ordinance, it only applies to evictions for non-payment of rent.
So it's one day different and some more things that have to be added in for the Minneapolis ordinance right now.
Right. Okay. Now, kind of going back a little bit to what Mike was talking about earlier about dual pleadings. So if, say, someone has a material breach of lease, but they're also behind on rent, would you need, if you were saying both, would you need to include a 15-day notice if you're evicting for material breach, if you include that non-payment of rent as well?
Again, in many ways, it's a lot easier to file for material violation of the lease right now than it is for the non-payment of rent. You don't have to give the 15-day notice. So it depends on what the landlord's goal really is here. One of the things that we haven't really talked about today is what's in this for the landlord. Right? If the landlord wins an eviction, they win possession of the property. That's what they win. And let's say we've got one of these tenants that we've heard about from some landlords saying, hey, this tenant owes me 12, 14 months of rent. You know, they owe me 20 grand. Where am I going to get that money back? Well, I don't think an eviction is the way to get that money back. I don't think it's very likely, unless you're thinking if I file the eviction, then they're going to finally go apply for rent help. If you're thinking that's the spur that they need to get them to apply for rent help and so that you can get paid. But as a landlord, if you've got a tenant that's a ton of money behind, realistically, the most likely way you're going to get that money back is through rent help, working with the tenant to get that money. If you file the eviction, the tenant leaves, whether it's on their own or the court makes them go, which is what you win if you win an eviction, you don't win money at the eviction. You got to go to a different court for that. And you can try to enforce that judgment if you win. You can try to collect the money from the tenant, but they might be hard to find. They might be hard to collect the money from. Maybe they don't have the money. Maybe they'll file for bankruptcy, which I think is one of the strong likelihoods that will come out of this pandemic, is a rash, not just tenants, but all kinds of people filing for bankruptcy over the next 3 years or 5 years, or whatever lingering effect that this is going to have. And so if I'm a landlord considering running down to the courthouse to file an eviction, the minute one of these days lines up where I'm allowed to file an eviction, I would caution you to think, well, what's my goal? Is my goal really to evict them, or is my goal to get paid? Because you might be able to get paid everything that the tenant owes if you work with the tenant versus filing the eviction. And so anyhow, that's one of the things that I just want to make sure we say today, because we have a lot of landlords that watch these programs, along with social service providers and tenants and all kinds of attorneys. And so it's just something that should be front of mind for any landlord considering an eviction right now, especially with a tenant that owes a bunch of money.
All right. This quickly. So how does a tenant know if they are, and how does a landlord know that they're in pending status? I know we just covered that, but if you want to cover it again real quick. So if we missed it, we need to reiterate it.
Sure. 211 is the entry point for applications to rent help MN, and they can also help a tenant find out what their status is, the status of their application. And another thing that we have found out from our conversations with Minnesota Housing is that tenants are finding out their status by email more than anything. So even though they're supposed to get an email and then a written confirmation, it's safest for tenants to continually check their email to find out what their status is.
So it's not by text, it's by email only.
By email.
Yeah, I mean, we're lawyers. Lawyers sort of live and die by email still. But the general public, I don't think, uses emails at all. So that's one of the things that if I'm a social service provider, I'm going to be stressing, is you need to make sure you're checking your email, because a lot of people don't check their email at all.
Yep. And I know 211 didn't necessarily have access to statuses up until a week and a half ago or so, 2 weeks ago now. So if it was something that you were trying to get in touch with them to get some sort of status update and you weren't getting it from them, might be worth recalling and rechecking now. They might actually have that access. This is another one that we've had a couple different variations of this question come through. What if someone applies, is waiting on it, hasn't paid rent in a while, and then gets denied? What happens there? Are they suddenly ineligible? Like if they appeal, what happens?
Well, I mean, the appeal is a whole different question, and the appellate process for that's something that I'm not sure that we're able to really comment on authoritatively yet. But if we look at our chart that we have up here, which is why we have it on the screen, we see that on August 13th, a landlord can terminate the lease for a tenant that's been declared ineligible versus one that's refusing to apply. There's a difference between those two things. And then on September 12th, the landlord can evict a tenant that's applied but has been ruled ineligible.
So if someone is denied in the program, say tomorrow, they're not eligible, the landlord has to wait until the 13th of August before they can terminate the lease for non-payment.
I think that's right.
Okay, that's
think
how
that's
I
right.
understand it too, but I want to make it very clear.
Again, huge difference between the tenant that just says, I will not apply, and I applied, but I got turned down.
Okay. And then Julia was wondering, is there any law that, or anything in the off-ramp law that includes resources for community engagement or ways that service providers and partners can basically assist with this process to ensure that tenants are informed of their rights and how to apply for assistance?
Yeah, again, the notice requirement of the session law is kind of the start of that. It says, here's rent help, there's 211, start with those places and see if you can qualify for rental assistance, which is going to be the thing that solves most of the problems that tenants have right now. Most of the landlords, I mean, well over 90% of evictions in general pre-pandemic were filed for non-payment of rent. And there's no reason to think that number will really change. In fact, it's probably a lot higher if you could ask every landlord today, hey, why would you file for an eviction? Well, they haven't paid rent forever, so I want to evict them for that. It's still going to be the number one reason why landlords would want to file an eviction. And so the fact that the landlord has to give a notice in those non-payment of rent cases hopefully will activate tenants to go apply. Because the situation's changed right now. They're no longer protected by these two giant umbrellas, the CDC order and the state eviction moratorium. Things have changed. All those protections are either gone or going away real fast, so you better go apply. And hopefully that notice will convince tenants to do that.
And there has been a lot of effort put into getting the word out on rent out MN and for applying. There are community partners that are working with the state on getting information out to tenants who have different language needs, who need assistance with the applications, and there is a push to get the information out. So that is happening.
We're going to change it up just a slight bit, give you two a little bit of a different use of your brain skills. Kim Tennyson, who is a landlord attorney, who has actually spoken on a couple of these webinars over the last year and some months, has sent over some scenarios and was wondering how you would advise or what you would handle these. So first, I think, Andrea, I think you're up.
Okay.
So first, my lease expired at the end of April. In early May, my landlord gave me a notice to vacate at the end of July 2021 because the property owner said they need to move back to the property. So assume proper notice was given. I've heard that this exception is no longer included in the off-ramping of the moratorium. When August 1st comes around, can the landlord still file an eviction for holding over after notice? Do they still need to give me a 7-day notice before they can file an eviction?
Rachel and I were discussing holding over again right before this webinar. The 7-day notice requirement of an intent to file an eviction was specifically included in the Executive Order 2079, and that is no longer in place. A landlord is no longer required to give a 7-day notice that they intend to file an eviction. Again, the off-ramp legislation specifically states that that executive order is no longer in effect. And again, the 15-day notice only applies to non-payment cases. And holding over for if a landlord wants to file an eviction for holding over after notice, it's my sense that that is something that, unless you come up with a material lease violation, that's something that can't be done for that can't be done until October. What do you think, Rachel?
I agree. I don't think that's a part of the exceptions. I mean, can you have a material lease violation if there is no lease to violate at that point?
That's the big question.
So my thought is that that holdover violations are going to have to wait until October 13th.
Mm-hmm. That's not to say that the landlord couldn't negotiate something with the tenant in the meantime. Very often situations like this where a landlord needs to move back in or wants to move back in, the tenant may be able to work something out with the landlord. So it doesn't get to the point where a landlord has to file an eviction. Once an eviction is filed, it's a public record. So it's entirely possible in situations like this or other situations that something could be worked out and negotiated so a case doesn't get filed.
All right. Anything to add, Mike, or would you like to move on to your scenario?
Let's go on to the next one.
All right. My lease expired about a year ago. I just agreed to move out by the end of July 2021. I signed an agreement with my landlord and she agreed in writing to return my security deposit so long as I move out and hand over the keys. I don't really care about the deposit because I don't have any place to move yet. If I don't move, can my landlord still file an eviction for holding over? So another holding over question.
Yeah, I don't think the answer is any different. I think that the holding over is not explicitly allowable under the new session law
Mhm.
that we've got. October 13th, sure. But before that, I think it's a lot different. I guess if I'm trying to think about things that a landlord might be able to do here, let's say that the landlord had planned on somebody else moving in on August 1, and in fact had re-rented it to somebody, counting on the tenant's assurance that they were leaving, even a written contract. So the tenant doesn't go, arguing, hey, you can't make me go till October 13th, and then you can give me a notice. The landlord might have an argument for what we call consequential damages at that point. Hey, you know what? I'm getting sued by the person that was supposed to move in August 1st, and I'm going to pass those costs on to you because this is all happening because you didn't do what you said you'd do. I think that's theoretically possible. It's not the same as an eviction, though.
All right. All right. And then final one. I've never had a written lease. I'm 8 months behind on rent and I'm working again, but I don't make enough to pay rent for the long term. What if I'm still behind with rent by the middle of October and the landlord gives me notice to vacate just because they want me to move and they don't necessarily care about getting that back rent? Am I protected from eviction if I apply for rent assistance? Andrea.
Well, a lot going on with that question. We did have another question come in the chat that I want to mention before we get any further with talking about rental assistance. There are, if you go to renthelpmn.org, there's information under resources about, there's frequently asked questions, and one of them is the eligibility requirements. They're really straightforward. You're a renter, you're behind on rent because of COVID or other reasons, and your income, your household income is less than 80% of the area median income. And there's charts on the webpage that list out what that is. Now, getting back to this question, my first thought is that this is potentially a negotiable situation where you know that you're not able to stay in a particular place, and you're able to get current with the help of Rent Help Minnesota. So I definitely recommend in this situation, definitely apply, because if you have a pending application with Rent Help Minnesota, then you are going to be protected from an eviction for non-payment of rent. But if you know going forward that you're not going to be able to stay there, this is something that absolutely you should consider negotiating with your landlord and negotiate an end to the lease. One caveat to keep in mind, if a tenant applies for rent assistance and they move, then the landlord will not get money for that application. And if they do get paid, they'll have to return it. And the tenant cannot take that rent assistance with them, so to speak.
Okay.
The safest thing, and we're saying this over and over again, if a tenant is behind on rent, to get the protections that are in place in the off-ramp, they really need to apply for rent assistance through Rent Help MN.
All right. I'm going to combine a couple of questions. A couple of the next ones are of the same variety. So Courtney, Marie, and David are asking about just in general, if, Mike, if you can go quickly over again, if you've applied for Rent Help MN and there's no other, it sounds like none of these have any other potential issues or exceptions. When are they protected until for non-payment of rent evictions?
So again, if the tenant refuses to apply, they aren't protected at all from a non-payment case. The landlord could go file the eviction with a 15-day notice officially on July 14th. If the tenant has applied and ruled ineligible, so they got denied basically, then on August 13th, the landlord could give a notice. On September 12th, they can go file the eviction for it. And then if the tenant is just applying for one, but it's a pending application, then they're protected through June of 2022. Those are the big rent help dates.
Perfect, thank you. Andrea, someone has a lease that's up at the end of July. This is Ruth. And they want to know what their rights are on August 1st, if their lease is up on July 31st.
May need a little more information to answer this. In general, if you have this plays into the holding over question as well. If the lease is up at the end of July, then if there's not an issue of non-payment of rent, you're really looking at a situation where the landlord really can't make you leave until October 13th. Again, there could be other things in play here, but if it's solely a non-payment issue, then you're looking at protection so long as there's a pending application until really until June 2022. In terms of what recourse a tenant has, if an eviction, if this does reach the point where an eviction gets filed, this could be an issue whether or not the lease termination was proper. We could see a lot of these issues playing out in court, whether the issue was whether the termination was valid under the off-ramp provisions or other issues there. But so long as it's not a termination for a material lease, a material violation of the lease, if it's not a termination because the tenant refuses to apply or refuses to cooperate with getting rent assistance, we're really looking at something where it's basically not till October 13th.
Okay. Mike, a tenant, is asking, what about late fees? What are the late fee legalities for charging late fees during COVID-19? Can you just kind of, we've had a couple of different late fee questions, so can you kind of just touch on when a landlord can charge late fees and how much they can charge and things like that?
Sure. So late fees are capped by state law at 8% of the tenant's portion of what they owe. So if they have some sort of subsidy, it's 8% of that subsidy. If it's just a market rate place, let's say the rent is $1,000, then the late fee can't exceed $80. And that's a state law that predates COVID by quite a bit. I think the real reason Mike's asking the question, though, is, hey, what about COVID-19? Did that stop late fees from being assessed? The only thing that we've talked about today at all, whether it's a federal or state moratorium that affected late fees, was the original CARES Act legislation banned late fees through July of last year. So from March roughly of 2020 through July. And if it was a CARES Act covered building, then late fees were not allowed at that point. But other than that, late fees are allowed to be accrued. I know it's been discussed at very high levels to eliminate late fees, but it never happened in an executive order. It never happened in legislation other than the CARES Act, which changed only because of, which ended July 25th. That was the last time any prohibition on late fees existed.
Yeah, and again, and the only piece of the CARES Act that really remains relevant right now is the 30 days notice. And the CARES Act does not apply across the board. It's only applying to covered properties.
And it looked like Mike was a tenant. He should call our tenant hotline. And he said that the 8%, he was being charged over 8%, that we'd want to talk to him about that, because that doesn't happen much. I think it's probably a 98, 99% compliance rate for landlords throughout the state. Most landlords understand the rule and charge well under the 8%.
All right, true. All right, so David is asking, are there protections for undocumented tenants?
A tenant is not required to disclose their citizenship status when they apply for rent help MN. So that is something that should not figure into the equation when applying for and getting assistance from that source.
Mm-hmm. And then the last of our pre-submitted questions, can a tenant be evicted if there's a material breach of the lease, but also has past due rent and has applied for assistance?
Yeah, I think the tenant could be, but the landlord would have to file the eviction just for the material breach, not for the non-payment of rent.
Yep.
I think that's got to be the answer.
Yep. It's really kind of two separate issues there, and the material breach is going to trump the non-payment issue at this point.
Once again, I would absolutely not recommend that a landlord write down non-payment of rent in that case. It could sink their entire case.
Okay, fabulous, thank you. We are going to move on to the Q&A questions. There are 66 of them in here.
No problem, no problem.
Let's see, we've got, so technically we're again scheduled to end at 3 and absolutely understand that folks we're under the assumption that we would be ending at 3. We do have a hard stop at 3:30 and we are recording this. So if you are leaving at 3, you can catch back up with our website and see the recording to get additional information. Thank you everybody for coming. We at one point, we had 299 participants that I saw at one point, Mike. So again,
I saw 303.
I saw
Oh,
303.
all right.
Yeah.
And there's still 230 of you that want to hear answers to questions. So
absolutely.
let's
So
get what we
thank you.
can.
And
Yeah.
again, we'll continue on until 3:30. But again, those of you who have to leave, thank you very much for coming. It's been really informative. So thank you. Okay, let's get into it. So I think this one is kind of the same or similar vein as what we just talked about. Would a material breach include a holdover situation where the tenant's lease has already expired or is ended now with appropriate notice in a month-to-month tenancy scenario? We kind of said that it's hard to breach a lease that doesn't exist for a holdover.
Yeah.
But if it's a month-to-month, then the same issues, the same material breach requirements apply that we've been talking about.
Yeah, this is something I expect we'll see this question resolved in the courts at some point.
Okay. All right. So this is from Anonymous, field partner. And now that the landlords have heard that there is going to be some immunity for tenants that have applied for the Rent Help MN program, they are telling us they are not going to participate so they can proceed with the evictions. I don't know that there's actually a question here, but
Yep. No, and this is something we've heard, and I think it's something that we will see to some extent, but probably not to the extent that I think this question is hinting at. Look, landlords are not in the eviction business. If they are, they're going to fail. They're going to fail as landlords. There's no money in the eviction business. They're in the rent collection business. That's what they do. And so if a landlord wants to get paid, once again, their best shot is to help the tenant apply for rent help. There are going to be landlords out there that say, you know what, this tenant has gamed the system since COVID started. This has been like the best thing that ever happened to them, and they're trying to rip everybody off. Okay, maybe you're right. But if you want to get paid, your best shot is still to go through rent help. Because if that tenant's gamed the system this long, they're going to figure out, well, they can ride it out a little bit longer and never pay you, declare for bankruptcy, and you're never going to get a penny. So if you want to get paid, helping the tenant apply is how it works. And while there are tenants out there that are gaming the system and getting every dollar they can or not paying whatever they don't need to pay because they're protected for now, we talk to these tenants. We talk to a lot of tenants, and what happens is they fall behind. They start to lose track of how much they owe. They realize there's no way they can get caught up, so they stop communicating with the landlord. It's a pretty common human reaction to hope the problem goes away or to at least hide from it. And so there's a lot of shame for a lot of tenants that are out there. They feel like they've somehow let the landlord down. They signed a contract, they want to live up to it, but they got fired from a job. It had nothing to do with their work performance. And so they're in this tough spot and they're not sure how to fix it. And this whole, everybody should know about this money that's out there. Not everybody does. And not everybody believes it. Not everybody believes that the government's going to swoop in and pay your rent, right? What are you talking about? I owe 10 months of rent. Why would the government pay that? Well, there's a program that does that right now. And so it can take some convincing, but there are people out there that have no idea that that really is something that's available to them. And so my hope is that landlords go with the Gordon Gekko mantra that greed is good and the money is what they're interested in, not the possession of the place, and chase the dollars, because the government is saying, let's try to make people whole, mostly landlords. keep the tenant's reputation
Mhm.
solid, but mostly pay the landlords what they were entitled to. And that only happens if both the tenant and the landlord work together.
Okay. We've seen variations on this next question. What should happen with evictions that have been filed under the family moving in exception under Executive Order 2079, but have not yet been heard or resolved in the courts yet? This is from Elizabeth.
This is a great question. We honestly we don't have a solid answer on that, again, because this legislation has just gone into effect today. And we'll see what happened. We'll see how the courts treat it. But the kind of the logical, and I know of I've talked to some clients who have cases who are in process right now that the case was filed under the family exception a few weeks ago, but the actual hearing hasn't happened yet. Executive Order 2079, which permitted that grounds for eviction, is no longer in effect, but it was in effect at the time the case was filed. So I would not be surprised if courts hold that it was legal at the time it was filed. So those are the rules we have to go by, and that exception is going to be permitted. We could
This
be
is a real
proved wrong.
gap, though.
Yeah,
this is a gap. This is
it's a
something that
huge gap.
the executive orders have tried to address that. The 2079 still has language in it that said, if you had a writ back in March of last year, here's what happens. So it actually addressed it. This new legislation doesn't. Just leaves that gap.
So that is,
Yeah.
that's
Well,
an open question almost.
see if we have a better answer next week. All right. Allison is a landlord and has a material breach with one of her tenants, and just wants to know if an email is adequate for delivering a notice to vacate.
Maybe an email is adequate. It depends what the relationship has been. If you
Mhm.
have an ongoing email relationship, I think that strengthens it. The safest route is to give a piece of paper with a photocopy of it. Not this law, but laws that deal with notices in general require them to be in writing. And most of those laws, case law as well, predate emails and texts. So our best answer is texts probably aren't good enough, and email might be good enough if you have an ongoing relationship. Because again, if it gets sent straight to the spam filter and the tenant never saw it, that is unlikely to be seen as a sufficient notice. So paper is the safest.
Okay. Chris, I'm going to take this one quick because we've answered a couple of times. Just under non-payment of rent, what if the tenant does not need assistance but still refuses to pay? If they're refusing to apply for COVID-19, then with the 15-day notice, you can start the eviction process now. If they just are ineligible and refuse, and unable to pay, or not paying, then you can start giving that 15-day notice come September 12th, and with a option to terminate the lease August 13th. All right. Michael is a landlord and wants to know, does the resident have to provide proof if they applied for assistance versus just saying they have? So again, that's the rent help MN a pending page, or it might be in your email, or calling 211 is another option there.
Yeah, it's my understanding that when a tenant applies, they apply, but a landlord can also create an account with their information. So it's possible to track that online and find out a status there, but you can also call 211 and find out from them what the status of an application is.
This one also has kind of been covered a little bit, but anonymous tenant is saying that they have never had a late payment in the 7 years they've been renting, but their landlord wants to renovate the house and wants them out.
Yeah, so I think that on October 13th, the landlord can certainly give a notice to terminate if the lease is month to month or something like that. At that point, they can give the right amount of notice. In general, the fact that you've been there 7 years, the fact that you have paid rent on time throughout doesn't really matter on that question. You don't have a lifetime lease. it's a month-to-month lease, it's a 1-year lease, whatever it is, that lease ends at the end of that time, and either side, is the general rule, can walk away and say, I don't want to do another lease. It's kind of a harsh answer, but that's the right answer under Minnesota law.
All right. Anonymous is asking, so for a non-renewal lease termination for material breach, can a landlord still go after a tenant for non-payment to recoup the loss of rental income?
That's a great question. So if this is meaning, if there's a termination for a material breach, wow, again, it's a separate issue from the non-payment. But if a landlord is going to terminate a lease for a material breach of the lease, then you're really looking at kind of, that's it, that ends the lease. They could certainly, I don't know, Mike and Rachel, what are you thinking on this? I think if they do the material breach, they may be SOL when it comes to the unpaid rent.
I mean, everything that's been said, except for the CARES Act, every other moratorium, whether state or federal, has very clearly stated that the rent is still due. So I don't think evicting someone for a material breach is necessarily going to limit the landlord from being able to go to just like small claims court and sue for that.
And it probably will also depend on what's actually stated in the lease. There could be language in the lease that could control that as well.
All right. All right, I answered that one. Shannon's had a couple of very specific questions to her case, and I'm just going to suggest that Shannon can continue working with us directly with very specific questions to your particular case. So I will go on. So Anonymous is asking, if the tenant completes a rental assistance application within that 15-day notice period, would they be safe from eviction?
Yeah, I think so.
I don't see why not.
Yep. The safe harbor. I don't think that anybody else has labeled it that, but that might just catch on. But the safe harbor provision probably says that, or it does say that the eviction can't be filed or it can't proceed if the tenant is applied. And so filed means started, but proceed is pretty much everything after that. And so, yeah, I think the tenant could apply for the rental assistance even after the eviction is filed and be protected by that law. Certainly before the eviction is filed. And that's really the point of the 15-day notice, is that it encouraged the tenant to apply before, because we really don't want landlords filing evictions for, wasting $300 and taking up time in the court's time if they don't need to, and if they're not really eligible to. Be much better for everybody if the tenant applied when they got that 15-day notice.
One winch, I believe, is asking if we can download the presentation. The presentations are recorded and will be available on our website, and I will post the link again in the chat. Previous Homeland Attorney Paul.
Hi, Paul.
Berg just wanted to say that y'all doing a grand job. So he says, excellent presentation, well organized. So. And
Rachel, Paul has watched many of these, and he's never said that before, to my knowledge. So the only real difference is you, right? You're running the show instead of Eric.
Oh, thank you, Mike.
Eric takes shots at me every week that we do these, though. So that's me doing it while he's on a plane somewhere nice.
Yeah, right. Where he can't defend himself.
That's right.
All right, back to business. As of October 13th, can leases be terminated or not renewed without cause? So,
yep, I think the answer to that is pretty much yes. Again, we have the one caveat, which is the June 1st, 2022 exception if the tenant has applied for rental assistance and the real reason is for non-payment of rent.
So I think this next one is from Lakeisha. If I'm pronouncing that improperly, I apologize. But they're just wondering, can a landlord evict if they have given notice to end the month-to-month lease due to a landlord and a relative wanting to move out of the unit. So that's the family exception again.
It's the family move-in exception that was, again, it was permitted under Executive Order 2079, but like Mike was saying, that is the big gap. At least the big gap we've noticed so far in the off-ramp, that is no longer a specific ground for eviction. So again, if there's not an issue with non-payment of rent or rent being owed, this is something that potentially the landlord would not be able to give a notice to vacate for until really after October 13th.
Okay. Thank you. Mike, Anonymous would like to clarify, landlords are now allowed to non-renew tenants. They just cannot evict tenants for holding over until October 12th. So that's a good distinguishing, when can they give a notice to vacate versus when can they start evicting?
Well, I mean, landlord can give a non-renewal notice for a material violation now, right? But just a standard, I want to end our contract. No, they can't give the non-renewal today. I don't think they can really do that like we've been talking about until October 13th. They'd need to wait until that time. But I don't think a landlord can give a notice today saying, I want you out by October 31st. I think they have to wait till October 13th under this rule to give a notice to be effective for the end of November, the end of
I think
December.
you're right
however much
about that.
notices. Yeah.
Yeah.
And that will
Alright.
matter, by the way, because that gets us into the winter. And a landlord might say, I want to give a notice to vacate as soon as I can, but there are a lot of leases that require 2 months notice that has to be directed towards the last day of the month. And so the earliest a lot of landlords would be able to give a notice to vacate for would be December 31st. And traditionally, landlords aren't big fans of tenants moving in and moving out on December 31st because it's really hard to re-rent a place for, you know, the end of December, the end of January. Those are hard months to re-rent for because nobody wants to move then because that doesn't sound fun for anybody. Yeah.
Aziz is wondering, and I certainly don't know the answer to this, but is money judgment obtained during COVID, is it now eligible for collection from the bank with a writ of execution?
There was an executive order that had limitations on garnishment and when bank accounts or wages could be garnished during the pandemic, but that is no longer in effect. So I'm not sure if that is getting to your question, but I can tell you that the executive order putting a hold on garnishments is no longer in effect.
Okay. Mike, to reiterate, we kind of covered this a little bit, but to reiterate, what does the CDC moratorium, how does it impact this rollout, or excuse me, off-ramp?
In my mind, it doesn't play much of a role at all, except
No.
it's a backstop. It gives it a lot more visibility. People are asking us about the CDC order, the Call Our Tenant hotline, not realizing that the state order still has a role to play. In fact, it's probably 50-50 people that contact our tenant hotline that ask us about the eviction moratorium. I think the CDC one is the one that matters.
Yep.
Even though it's never really played a real important role in Minnesota other than being a backstop. Again, it specifically defers to a stronger state protection if one exists.
Right. Anonymous is asking 2 questions, mostly clarifying questions. They say, the landlord gave you notice on 6/19 to vacate the property on July 1st, 2021. I'm not sure if that's like June 19th or if that's June of 2019. But they understand that the notice was illegal because she gave the notice during the executive order. So they'll need to send a new letter of eviction. Is this correct?
I recommend you give our hotline a call. I'm thinking there's a couple things in play here that I would need to know to give a solid answer on this. If a notice was given on June 19th of this year to vacate by July 1st of this year, that is not going to be a valid notice to vacate right there. In general, if your question is, can a landlord give you a notice to vacate? If they've given you a previously invalid notice to vacate, the notice would have to fall into the permitted categories under the off-ramp right now. So I totally recommend you give our hotline a call so we can take a look at what's happening with this situation.
Okay. And then the second part of the question was on a year-to-year lease. And is it Minnesota law that the landlord must give 2 months notice, even if the lease says 1 month?
No, there's no law that says that a landlord has to give 2 months notice if the lease says 1 month's notice. It would be what the lease says.
Yep, the lease is going to control. And if it's a month-to-month lease, then you're looking at least a rental period's notice.
Okay. Andrea, Kathleen would like to know if you can elaborate a little bit more on the differences between what is allowed on September 12th and then again on October 12th of the off-ramp. I think that's what Kathleen is asking.
Well, yeah, looking at the timeline, October 12th is more or less when everything goes back to normal, except for tenants who have a pending application for rent assistance with Rent Help MN. September 12th is when a landlord can evict a tenant who owes rent who is ineligible for assistance through Rent Help MN. So that's the big difference there. And October 12th is basically when the majority of the off-ramp protections end.
Beth would like to know so for the COVID-19 emergency rental assistance, is it just Rent Help MN? There are multiple programs using COVID federal dollars, but only one Rent Help MN program.
Right. So the law actually refers to 2 specific programs. I'll say exactly what they are. You can look at them in the session law if you want to look at them yourself. But it refers to under the Federal Consolidated Appropriations Act 2021 or the Federal American Rescue Plan Act of 2021. So it's very specific references. Notably absent is the CARES Act from those 2, which there are still some dollars, I believe, that are still being dispersed under the CARES Act, but this is referring only to those 2.
And then, Mike, can you go off of this one for Katie, just to elaborate the specific language for the information about where to get rental assistance for the notice requirement?
Yep, the notice requirement, again, if I'm a landlord, I'm going to take the text right out of the law. There's no reason to embellish on this at all. You have to have at least this much information. You can have more information. Like I said, the one thing I would add would be, it says name the total amount of rent due in this 15-day notice. But I would say the total amount due. If you want to get paid everything, you should list the total amount due as a landlord. But yes, it does talk about that you have to, as a landlord, tell the tenant that they should visit renthelpmn.org or call 211. That's a direct quote from the language there.
Okay. And Beth asks that 15-day notice has to be written, correct?
Yeah, right. Yeah. Same section of that article. Yes, it has to be in writing.
I'm going to elaborate on that a little bit. Would an email work in this case?
Again, it's the same analysis we did before. An email might be good enough if there's an email relationship ongoing between the parties.
Okay. Shannon has actually an interesting question about with that, if they give a 30-day notice to vacate, do they have to have a separate notice that clearly says it's a 15-day notice for non-payment of rent, or can that be lumped into one of the other notices that needs to be given?
So if it's a non-payment of rent issue, so they give a 30-day notice. Does that include the 15-day notice?
Or does it have to be a separate?
I think it should be separate. You're really looking at two separate you're looking at notices for 2 separate things, basically. One is the notice of notice to vacate or the notice that the lease is ending, and the second is the notice of filing an eviction.
Now, there's nothing in the Article 5 off-ramp language that would prevent, say, a landlord from giving what's in that 15-day notice 30 days ahead of time, right? So changing it from a 15
there's
to a
not,
30 day.
No, it says
Yeah.
at least. It
Mhm.
actually has
Yeah.
that wording in there. So it can be 16 or 30 days. Sure.
But so at the 30-day mark, you could hand your tenant
Mhm.
2 pieces of paper.
We get a
Alright.
lot of questions actually kind of following up on something Mike said about texts. And in a lot of respects, the law has not caught up with technology. And I really caution against using texts for really any kind of landlord-tenant business. It's really safest to do everything in writing with paper, and to give notice with a piece of paper and keep a copy. Emails are kind of the next best thing, but texts are kind of dicey.
And that notice only applies to non-payment cases, not to material breach cases or anything else.
Right.
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 All right, anonymous social worker would like to know, what do you recommend if a tenant feels that a landlord is using material breach as retaliation for non-payment? Example, tenant is $3,000 behind. Manager says owners are trying to find a way to get you out and now are mentioning that the yard is messy.
Yep. That's a real possibility.
That's yep.
Yep. No question about it. Certainly tenants tell us that that's what they think is going to happen. Again, I go back to the whole, is a landlord in the eviction business or are they in the rental collection business? And so my hope is that this isn't something that's personal. Tenants, when they call us up and they say the landlord hates me, this is very personal. The landlord just is out there to get me. I've almost always told tenants that's just almost certainly not true. Landlords don't have the time to hate you. That's not what they do for a living. They collect the rent. They don't. This is actually a bigger insult. They don't care enough about you to hate you. That's not the relationship that you guys have. You're a tenant. You pay your rent. As long as that's done, they don't think about you that much. They don't spend time stewing. But I think things have changed during the pandemic. I think that there are a decent number of landlords out there that have started to think the tenant's ripping me off. They're gaming the system. So I think there is more of a personal animosity. But the question is, will that override the landlord's bottom line needs, right? They got to pay the bills. They got to pay the mortgage. How are they going to do that? Help the tenant apply. But are there going to be landlords that use the material breach for a reason to evict somebody that's really about non-payment? I have no doubt. I have no doubt of that.
Oh yeah. Yeah. And if push comes to shove, if it does reach the point where an eviction is filed, retaliation is a possible defense. So it is definitely something that if things proceed to the eviction stage, that is a defense that can be raised. It's more of it's a shield. It's not really a sword. It is a defense that the tenant can raise.
Okay. All right, and that June 1st, 2022 only applies for non-payment for pending applications. It's not for any other like illegal activity or anything like that, eviction.
Correct.
All right.
Yep.
Has there been any news of enforcement mechanisms for the off-ramp?
I think it's the courts.
Yeah, it's the
Right.
courts. We know that the Attorney General is not going to have the same kind of role in enforcing this as they had with the executive orders. But like Mike said earlier, they do have a consumer rights division. So it's not going to hurt a tenant to make a report to the Attorney General's office, but the Attorney General is not empowered to act during the off-ramp as they were with the executive orders.
Okay. Dana wants to know what happens if the tenant applies for assistance but continues to not rent. I think that means that if the tenant leaves.
Oh, if the tenant's gone physically?
Yeah, if they
What's
apply
that?
for assistance and then the tenant goes.
I don't think that the money's going to get paid. I guess there's a chance
Right.
that the check would get issued sort of as the tenant's on the way out the door. I suppose that's possible. But no, I think the whole point is to stabilize housing.
Yeah, the tenant has to be living in the unit for the landlord to get the rent assistance. So if they apply and move out, then either the landlord won't get paid at all, or if they do get paid, they have to return the money to the state.
And I'm not sure what happens if you don't return that money. You might get in serious trouble as a landlord there.
Right.
Sandra just has a quick question. She's a landlord, and they were saying, my tenant is now paid up on back rent and the lease ends September 30th, 2021. Can I give them a notice of non-renewal of the lease by July 31st, giving that 60-day notice requirement?
I'm trying to do math in my head. So 60 days from July is not going to get you into October.
Yeah, because they can't even give the non-renewal notice until October
Right.
13th. It doesn't really.
Yeah, if they give a notice now, it's not going to be valid.
Mm-hmm. Anonymous wants to know, how does the new rule apply to residents who vacated their lease in a bankruptcy just prior to the eviction moratorium? They currently do not have a lease. They are in default due to non-payment, and they have applied for rent help MN. So I'm not certain.
I'm not sure how rent help's going to help. They vacated.
Yeah, I'm
Right,
not
so
certain if the tenants aren't there, then they can't do anything.
Yeah, they're not going to
Yeah.
qualify for the. I mean,
They're
they
not
can
gonna
apply.
qualify.
They're not going to qualify. It doesn't pay off old debts.
Another anonymous would like to know, can landlords apply for rental help on tenants themselves, or does the tenant have to do it?
The tenant has to initiate the application. There is another program, Project Zero Balance, where the landlord can apply. But as Rent Help Minnesota is structured right now, the tenant has to make the application. The landlord can help, but it is something that the tenant has to initiate.
Okay. All right. Cassie or Casey just wants to clarify, if a tenant's lease ends on 6/30 and it's not renewed, then the landlord can evict them. They want to know, is it 7/14? Didn't mention anything about material lease violations, just not renewal and holding over. So I think that's the October 13th.
Yep.
That's our same October 13th
Yep.
answer. That's
Yep.
right. Yeah.
All right. So it is, by my clock, 3:28. We raced through as many questions as possible. We got through about over half of them that were in the Q&A. So I applaud you for that. Great job. So again, this will be recorded and put onto our website. I have put the links up in the chat. Thank you all for coming and asking all your great questions. And thank you, Mike, and thank you, Andrea, for all of your excellent answers and responses.
We'll see you next week.
And yep, we will be, whoops, I went too fast. We have 2 upcoming webinars next July 7th, court updates on the eviction process and any other updates on the eviction moratorium off-ramp. And there's the rent help MN. So thank you.